Hello again from Fired Up. I'm your host for the show, Bob Irwin, broadcasting from Rigel Studios here in Las Vegas, Nevada. This show is about guns, related politics, and self-defense issues. Fired Up is on our website, firedupwithbobirwin.com, and on the American Guns and Glory Network. If you go on YouTube, you'll find them too. We're on numerous other media. A new show is broadcast every Thursday at around 5 p.m. Pacific time. The audio feed is rebroadcast for radio listeners Saturdays at noon on the Nevada Talk Network. You can check out KELY1230.com for the station in your area. Questions or comments can be sent to email to me at bob@firedupmail.com. Again, that's bob@firedupmail.com. Or you can leave a message on my office recorder at 702-257-1060. That's 702-257-1060. If you leave contact information, we'll respond by email, text, or telephones. Questions directed to my guest. Actually, my guest today will give his own contact information. So you'll get that just a minute or two into the broadcast. There's several hundred defensive uses of firearms every week in the United States, rarely truthfully covered by mainstream media. We always present a few for our listeners' education. Most are good shootings. Some are questionable. Sometimes they're just plain wrong. But all are educational for firearms owners. The individual incidents are generally adjudicated under local law. The advice here might not apply to listeners in different jurisdictions. Stories are often now on this show paraphrased for clarity by translation from police jargon, lawyer speak, and regional dialects into standard English, American English. The incidents are as reported except the names are omitted. My guest today is California and Nevada attorney Donald J. Green. Don, if you would, a bit of your background.
Okay. Thank you. Again, Bob, it's a pleasure being on your show and here at Rigel Studios. For those of you who don't know me by now, my name is Don Green, and I'm a lawyer in California and Nevada. I'm principally based in Nevada. I've been a lawyer 36 years this year. The principal emphasis of my practice has to do with firearms, both the administrative, criminal, representation before the FBI, representation before the ATF, litigation of firearms-related issues, Second Amendment type issues, Nevada State Constitution issues, and I do consultation to federal firearms licensees in Nevada and California, and also to gun shows. Your listeners and viewers can reach me on my direct cellular at area code 702-409-8239. Or you can Google me at, just put in the browser, Donald J. Green Gun Show Lawyer, and it'll come up with several links, including our website. Thanks.
All right, this first story is going to, it's a little off of what we normally run. This is not a shooting case. This is a case from the Nevada Supreme Court, which is very likely to turn all gun owners more or less on their ear. Let me read through it and you'll get where I'm going, and then I'll have Don comment and I'll have some comments. A new Nevada domestic violence law now is in 2019. The Nevada Supreme Court has ruled that people accused of misdemeanor domestic violence have the right to a jury trial based on the fact that a 2017 law cancels the defendant's right to keep and bear arms. In trying to make victims safer, our legislature added a law that anyone convicted of misdemeanor domestic battery loses their right to possess firearms. We're all well aware of that here in Nevada. That right, however, is enshrined in the Nevada Constitution as well as the United States Constitution. The unanimous ruling came from an appeal by a defendant who was denied a jury trial in Las Vegas Municipal Court and was subsequently convicted by the trial judge. The ruling, written in this case by Justice Lydia Staglich, the seven-member court cited the state law enacted in 2017 that requires those convicted of domestic violence to give up their firearms. Failure to comply is a felony. resulting in up to 6 years in prison. The potential of losing a constitutional right guaranteed by this in the Second Amendment, this is quoting the judge now, commands the conclusion that misdemeanor domestic battery is a serious offense. She wrote in part, this is a rather long dissertation, I just put the high points in here. Given that the legislature has indicated that the offense of misdemeanor domestic battery is serious, it follows that one facing charges is entitled to the right of a jury trial. One would think our thoughtful legislature could have seen this one coming. Serious domestic battery is always charged as a felony to take these jerks off the street and lock them up for years. The DA always has the ability, or the prosecuting attorney, if he gets a police report that is labeled misdemeanor domestic battery, he reads the circumstances, he can always charge it as a felony, and they generally do. So it's the charging, this is the fault of the charging party, that some serious cases aren't charged as felonies where they would lose their firearms rights anyway. This issue now, I don't even know where to begin, so I'm going to turn Don loose with where we're going with this. This is going to be an amazing thing to get through.
That is correct.
Mr. Green.
Bob, good news, bad news. Here's the good news for those accused of battery domestic violence. And I've been speaking to these people all of my professional life, and more specifically since 1996, when the United States Congress enacted what's known as the Lautenberg Amendment. That was in direct reaction to a very famous killing in Southern California involving a celebrity former football star. And in fact, Representative Lautenberg actually said on the Senate floor that he is tired of seeing women being killed by domestic abusers who use firearms. This was during the Clinton administration when the Democrats controlled both the House of Representatives and the Senate. They proposed the law under Title 18 of the United States Code, Section 922G. And it says that whoever having been convicted of a crime of battery domestic violence as defined under any federal, state, local, or tribal law is forever barred from possessing a firearm, period. Now, in response to that, we had, of course, a more clear issue in Nevada Supreme Court, in Nevada legislature. And in fact, several years ago, some of our courts started to put in the battery domestic violence admonishment of rights, the certain things that you could not have, including firearms. For example, now in the Las Vegas Municipal Court, there is a bright, it's either a bright orange or day glow orange admonishment, which is so bright you can't miss it. You could probably see it from the Hubble telescope. Okay? In English, it talks about you can't have the firearm. It's also in this day glow yellow in Spanish. Again, probably see it from the Hubble telescope traveling at 18,000 miles an hour. Okay, here's the thing. Here's the good news. The good news is that these defendants will have a jury of their peers decide on the issue of battery domestic violence. Now you have a single trier of fact in misdemeanor cases, both in the municipal courts and in the justice courts throughout the state of Nevada. Now, there's nothing wrong with one person deciding your guilt or innocence. I've done many bench trials at the misdemeanor level and at the district court level. And I have all the respect in the world for judges, but sometimes when you've got a victim, whether it's male or female, coming in and just crying these huge crocodile ears, it can't help but affect somebody. But if you've got a jury of your peers, for the defense attorney, all you need is one. All you need is one person to say, he's not guilty, it's a mistrial. Or all 12 say, you know what, she's making it up. She just wanted to go with her boyfriend. She wanted more child support. She wanted to get an advantage in the divorce. She wanted the kids, whatever. So that's one of the points. Now, the pundits against this decision, including Our Attorney General, who last week in the newspaper said that he can't wait for a victim to be killed as a result of this decision. And he's going to talk to federal and state officials about what can be done. Well, wait a minute. Under the Nevada Constitution, the Attorney General of the state of Nevada, who is a constitutional officer, has the following duties. Number one, he must faithfully support and defend the constitutions of the United States and of the state of Nevada. And he must fully and faithfully execute all of the laws of the state of Nevada and the statutes and regulations. And he must follow the decisions of the Nevada Supreme Court. If I said about what he said about the Nevada Supreme Court, I'd be on state bar proceedings today.
Yep.
But unfortunately, I didn't say it. But that's the issue. You've got people who don't want to enforce the law when it comes to firearms. So the issue is not the firearms. The issue is not the fact that it's going to cause commotion in the municipal courts, because there's battery domestic violence courts cases in every single municipal court of the 6 departments we have in Las Vegas, the 3 departments you have in Henderson, the 1 in Boulder City, the 2 in North Las Vegas, and those that out in Moapa and Jean and all the other counties and townships in this state. There are battery domestic violence cases every single day or every other day or every week. Now, the inconvenience is not there. All you have to do is, hey, some of those justice courts are empty in the afternoons. So, whether they're not having drug court or veterans court in the justice court program, schedule the jury trials at that time. Now, the thing is that I've done over 70 jury trials in state and federal courts in Nevada, Arizona, and California. And the average jury trial, shake and bake jury trial, is going to take over half a day to pick the jury. Is there something like a short jury trial like we have in civil cases? We have a short-term jury it's 8 people.
Right.
Now it's in a civil case, they don't have to be unanimous, but could there be 8 people and have a short jury trial and possibly limit the number of witnesses? That's a possibility, but you can't limit the defense. I can bring in 1,000 witnesses as long as their testimony is relevant. Now, that's the good news for defense attorneys and defendants, because you've got that added element. Because if you get convicted of battery domestic violence, here's the bad news. If you get convicted of battery domestic violence, or your attorney says the DA will give you an assault or a simple battery or reduce it to a disturbing the peace, you don't have to go to trial and you don't have a battery domestic violence conviction. Oh, great. That means I can have a firearm. Wrong.
Oops.
I call to your attention an unintended consequence of this decision, which is not in the decision itself. And that is Title 18 of the United States Code, Section 922G, and the Code of Federal Regulations. I'll have Bob explain the Code of Federal Regulations in a minute. Those regulations state that the FBI and the Bureau of Alcohol, Tobacco, and Firearms must look at the underlying conduct to determine whether or not you are entitled to a firearm. So if you have a battery domestic violence and you get that reduced to an assault, you're not out of the woods, because the FBI is going to say that the underlying conduct fits the federal definition. And I have cases pending before the FBI in Clarksburg, West Virginia on this very issue. I've got some of them where my clients were never even charged with battery domestic violence. But the FBI is saying that the conduct is enough so that it fits the federal definition. Now understand, these people in Clarksburg, West Virginia, the FBI people, they're good people, but they're just applying the law as they see it. And the U.S. Supreme Court has ruled that a federal agency or a state agency it has a lot of discretion in the application of its own regulations. So, unintended consequence, bad news. If you plead to a battery, if you plead to an assault, a battery, a disturbing the peace, anything short of a dismissal, you're going to lose your firearms, and you have to appeal to the FBI. And once you appeal to the FBI, that's it. You got to go to federal court, and the federal court is probably not going to overturn the FBI. So that's how I see it, Bob. For the consequences of this decision is a great decision, and it's a good start because it's showing that the courts are not putting up with this mainstream media, this hysteria, this anti-gun hysteria. That we still have the courts as a remedy, which you and I have talked about on hundreds of occasions, both here and at gun shows.
The issue, from my perspective, is Don is more into the legalese, but I can tell you exactly what's going on from a lay perspective of a gun expert, if you will, that deals with this. The courts apply the law. There's some famous quotes by numerous judges over the years, going back years, that I recall one where the guy's valet said, as he's leaving in the morning, have a good time dispensing justice. And the justice, you'll know who it was, I'm sure, turned to his valet and said, I'm not going out to dispense justice. I'm going to apply the law. The FBI, in their feelings on these things, they look at the underlying facts, and if they believe, in their opinion, the judge, and this is in their statutes now, if the judge could have sentenced you to more than a year and 2 days, we got rid of the year and a day thing because the courts got around that too, then as far as the FBI for the background check is concerned, you are a felon. Therefore, you're barred from having firearms basically forever unless you get a presidential pardon or something like that. And even those are rare and few and far between. The point is that when you have individuals that commit and plead guilty in court on a plea deal, where they come to you and say, you know what, just as Don said, Mr. Smith, we don't want to go to trial on this. I'll tell you what, we'll just charge you with misdemeanor disturbing the peace. And if you plead to that, we'll give you a $100 fine and you can go home. And you take that plea. Before this decision, that stood. Now it doesn't. So now you are looking at guys who really didn't do anything. They're trying to avoid a trial. And like all other crimes, there is misdemeanor domestic battery. There is felony domestic battery. They are different things, and they're looked at differently by law enforcement, by the courts. But the Nevada Supreme Court now has said, if you are going to plea or going to be charged with misdemeanor domestic battery, the penalties are what we use for felony domestic battery. So they need to have a jury trial. As far as what Don said, when they don't have time, they don't have the space to do the trials, so our Attorney General said that, and I believe somebody from the DA's office, although Steve Wilson hasn't actually directly commented on this, somebody in court services did, that we don't have the facility to have jury trials. I've worked in misdemeanor courts and municipal courts and justice courts as a bailiff all over the southern end of Nevada, and they all have a jury box that was built in when the system was built, and we use them generally just to house the prisoners, to keep them separate from the regular people. When we've got guys in prison, they're prisoners for a first hearing or a plea agreement or whatever, we sit them in the jury box. They all have jury boxes. I've never seen one that didn't have a jury box. But so that the thing that the courts can't do it, but I'll tell you where the problem will arise, is now we need hundreds and hundreds and hundreds more jurors available.
That's right.
Because everybody settles these on the courthouse steps. I was at a luncheon where a couple of judges spoke yesterday about the problem with juries, and they said, when you get the jury summons in the mail, there is a 1% chance that you will actually hear a case. There's an 8% chance that after you check in, you'll actually be picked for a case. Most people are sent home. So, and the problem is, as he was saying in his little speech, He's seating a jury that afternoon for a trial which is projected to go 9 months. 9 months. How do you get jurors who can commit to coming to, they don't do it 9 months in a row, 12 hours a day, right? They do an afternoon, a morning, an afternoon, whatever, and split it up. So the people can still live their lives. But the only people you could get to fill those positions now are unemployed. And thanks to Donald Trump, we don't have so many unemployed people wandering around that can fill these spots on the jury. So they always come up with great excuses. And one of the things he pointed out, which is subject of another show, felons can now be on juries. Can you believe that? Anyway, I don't want to get into that now. That's the subject for another show. But anyway, the point of the matter is the courts are equipped for that. The jury regulations, the people who subpoena jurors and have you come in for jury duty, are going to be absolutely overwhelmed. And if you think you get a jury summons every 3 months now, just wait. It's coming. But this has to be, if we're going to take away a constitutional right from somebody, they do have a right to a jury of their peers to decide if they're guilty or not. That's the whole basis of this story. Anything else on this, Don?
Agreed. Again, you very good point that you make. We got a lot of jurors in there, and perhaps you're excused, but you need to report to the municipal court. You need to administration. You need to report to Justice Court administration for possible use as a juror in a like you said, a misdemeanor or domestic battery case. Now, I can see what's going to happen is the DA is again going to try to just say, oh, we'll just give all these deals out. But the attorneys must be aware, and the defendants must be aware. Your listeners must be aware. Your viewers must be aware. Do not plead to a lower offense unless it's like the evidence is overwhelming, beyond a reasonable doubt. There's video evidence or whatever, or you've got multiple convictions and you really don't care. But those people whose rights have been taken away, and that's the issue. They don't care about the jurors. This is not an issue of administrative convenience. This is an issue of power, and the exercise and wielding of that power by those people who want to use gun rights and guns as an issue for political purposes. That's my take.
There'll be more on this, I'm sure, on subsequent shows, because we are entering a quagmire here of changes in the legal system and the way the courts handle all this stuff. The Nevada Supreme Court was absolutely right in their decision. As I said, it was a unanimous decision. It is not that they're approving domestic battery. They're not. There's a female judge, domestic violence judge, the female judge in the Supreme Court who wrote this decision, but they all agreed to it.
Yes.
And there's some liberals and there's some conservatives on there. And when you get a 7 out of 7 decision,
solid,
it's called. That's it. You know, I love watching attorneys when we have a Supreme Court case, they're arguing and they say, but the minority said this. Mm-hmm. When I got my police academy training, they told us that what the minority said doesn't matter. It only matters to lawyers. The decision was handed down. If it was only by one more judge than was against it, that's the law, right? So there we're going to be. I want to take just a sec. Well, let's skip that. I'm going to go into this other story. We probably have time to do one more story. I've got some friends and commercials, but I'm going to let that lie. We've got about 6-7 minutes, so I think we'll do okay with this. This second story is from WKRG TV5. It's CBS on the 4th of this month, a few days ago, in Baldwin County, Alabama. A 44-year-old woman is hospitalized after being shot Thursday morning in a home near Daphne. Daphne? Yeah, Daphne. If you know where that is in Alabama. The homeowner on Collier Loop Road was in the bathtub when her children heard a commotion in the front of the house. They go back and tell the mother that someone is in the house. The family doesn't know who it is, and they should not be in the house, reports the Baldwin County Sheriff's captain. His name is Clint Clattenhead. So they respond deputies. It turns out it's a woman that the resident knew who used to live there. This 44-year-old resident commands the intruder to get out of the house. The intruder does not leave. The resident gets a firearm out of the bedside table and again tells the intruder to leave. The sheriff reports the information he has. The intruder then reached for the resident's gun, attempted basically a gun grab. The intruder was shot once in the abdomen with a .38 caliber handgun. We can presume that was a revolver for all you gun folks out there. The homeowner is shaken up but was not injured and is cooperating with investigators. The sheriff added, she says she's never shot anyone. That's what she told us. That's true with most people with self-defense. Names of those involved have not been released, nor has the condition of the woman that was shot. It will be up to the Baldwin County grand jury to decide if anyone will face charges in this case. This issue of is really caused by a tactical thing, I think, here. Statistics tell us that 90 to 95% of intruders flee if they're warned. That being said, the other 5 or 10% don't cooperate. Try to dial 911 as soon as you realize there may be a threat and leave the phone off the hook. That's if you don't have a cell phone, leave the cell phone on. Good practice is to keep your distance from any intruder and keep furniture in their way. It makes it less likely they will try to grab your firearm. The intended victim here is probably okay in Alabama. I'm relatively sure she will be. In Nevada or California, we probably have a little different case. So, Don, I toss it to you.
Thank you,
What do
Bob.
you think?
Let's look at this case. First of all, in Alabama, she's probably okay. In California, here's the problem. The district attorneys, mostly in the coastal counties, San Francisco County, possibly Ventura County, kind of inland a little bit, definitely Los Angeles, San Diego County. Here's the problem. The homeowner who's in the tub, kids are screaming, the homeowner, hey, get out of my house, doesn't get out. Then the resident gets the firearm out of a bedside table and tells the intruder to leave. San Francisco County, homeowner's going to jail because she has a firearm which is loaded in the house rather than the ammunition being separate. And then when the homeowner was wrong in the first place. So was there an assault by the homeowner against the intruder? Yeah. Felony assault with the use of a deadly weapon. Child endangerment. Use of a firearm where children could be harmed. Attempted murder by the shooting of the victim, even in your own home. It's as absurd as it sounds. Do we not hear these things often enough so that you and I are not jaded to it, but that it's not unusual for us? That's the point. It's 50-50 in California as to whether the homeowner will be charged. Second, in Nevada, I think it's a better case for the homeowner because, again, this is in the morning, taking a bath in your own home, children are screaming, somebody's in the house, the former resident or the former roommate is in the house, get out of here for whatever reason, doesn't, and then it is the intruder who reaches for the firearm, according to the reports at which we have. Right. So it wasn't as if the homeowner had put the firearm out there, I'm going to kill you, I'm going to shoot you, but it was just the reverse of it. So was there an accidental discharge? Well, could there be an accidental discharge inside the home? I doubt if she's going to be charged in Nevada, but it's still a possibility. Discharge of a firearm in an occupied structure. Assault with a deadly weapon, attempt murder. I doubt if those would be charged in Nevada. Probably not in Alabama where this thing occurred, but in California, 50-50. We are unfortunately out of time for this week's show. I have one more story that's just that in reverse, where the homeowner did everything right. We'll pick it up next week.
You can check out our recent shows at firedupwithboberwin.com. It contains several dozen recent episodes. Well, I'm just out of time to say anything. We'll be back next Thursday on our website, firedupwithboberwin.com, on YouTube at the American Guns and Glory Network, and on numerous other media. Thank you so much for watching. We'll be back on this issue next week, I'm sure. Have a good afternoon.
Thank you.